Every weekday, 288,000 drivers pay so that 632,000 drivers can use the Metropolitan Highway System. That is constitutionally offensive. This case is about checks on the power of government to exact charges from citizens. Unelected government officials cannot impose taxes.
I take it that the drivers get some value, at least those that are driving on the toll road.
The drivers do get value, but
Very specific value that other people don't get that don't drive on those roads.
Indeed they do. Giving me 42 cents of an exclusive benefit doesn't justify charging me 52 cents for benefits everybody gets for free.
Is it your claim that every member of the class does not ever drive on the non-toll roads?
Oh, not at all. There's certainly
So they get the
usage.
benefit of those too, right?
Indeed. But again, I pay 42 cents for the value of the toll road. 58 cents of what I pay goes for benefits that are shared by all, and that's the distinction here. I'm sorry?
What a shame.
The distinction here is, here, let's do it this way. Think about a fee-charging fee facility as a box of services. If you want into that box, you must pay. And the benefits paid for by that fee must stay inside the box. Make the box as large or as small as you like, but you must apply these exclusivity tests.
What do you say about Article 78? Article 78 expressly permits fees, duties, excise, or license taxes regarding automobiles to be used for mass transit.
There's absolutely no application of Article 78. We're talking here about whether, if this were determined to be a tax, as we believe it is, not a user fee, whether the legislature has affirmatively and expressly delegated a taxing power to the MTA through Article 78. It's not done so. There's nothing in Article 78 to suggest that, Your Honor.
I'm sorry, so I'm lost a little bit. Are you saying that that a toll is not a fee, duty, excise, or license, or are you saying that the legislature, when it enacted Chapter 81A, Section 10B, did not grant the authority to charge tolls?
This Court has looked at exactly the same type of enabling legislation, precisely the same words in the Massport versus East Boston case, Your Honor. Exactly the same enabling legislation, and concluded that that was not a delegation of taxing power. The MTA does not have taxing power. There's no judicial review provided. There's nothing here that gives the MTA taxing power. So it is unelected officials who have the right to charge a user fee.
So you say they don't have taxing power. They're expressly allowed to charge tolls.
They are. They absolutely are allowed to charge tolls, Your Honor. But the right to charge tolls is not the right to do it illegally.
Well, isn't that conclusory? I mean, the question is, what authority does the legislature? I mean, I'm losing you here. I mean, yes, you say it's illegal, but that's the conclusion. The question is, why are we compelled to come to that conclusion?
Well, and for two reasons, both under the Massachusetts Constitution and the federal Constitution. The constitutional principle here is that only the legislature can tax, and states cannot impose undue burdens on interstate commerce. And it's the exclusivity concept that gets at that in both the Mass and federal constitutions. So it's exclusivity that distinguishes a valid user fee from an illegal tax in Emerson.
But if the MTA was given the express authority to charge fees but not tax,
yes,
how does it follow that, just assuming for the sake of argument, that it is an improper fee, how does it follow that an improper fee is necessarily a tax?
Well, that's what Emerson decided. And it's critically important here. We go all the way back to the opinion of this Court, opinion of the justices in 1925, that said one of the critical reasons for adopting constitutions was to distinguish whether only the legislature can impose taxes. So Emerson sets up this very clear distinction. User fees are those that are paid for exclusive benefits that are exclusive to the fee payer, while taxes are paid for shared benefits, shared with the general public. So that's the analysis we need to do under Emerson here, is to determine whether this is tolls are exclusive to fee payers or paid for something that's shared with the general public.
But
If
did the
shared-
entity in Emerson College have taxing authority?
I'm sorry?
Did the entity in Emerson College have taxing authority?
It did not. It was for the fire protection.
But who imposed the fee?
City of Boston.
City of Boston imposed the fee in Emerson, and in Emerson...
But the City of Boston has the authority to impose a tax.
Well, in that case, the question was it a user fee or not? And let's look at it there. We had augmented fire protection was what was being paid for ostensibly by that fee, but the court found that it paid for not only augmented fire protection, but also for general fire protection. It was a shared benefit, and thus it was a tax, not a valid user
But the
fee.
difference, or a difference, at least the Attorney General argues, is that in Emerson, there was no greater benefit for the building owners that needed to pay this augmented fee than anybody else was getting. Whereas here, you have the toll payers getting an exclusive benefit, that is, using the toll roads. They also have the benefit of the other roads. So other people have a lesser benefit, but they do have a special benefit that nobody else has.
Let's imagine that the MTA decides to impose a 2% net income tax on everybody in the Commonwealth. They can't do it. They don't have the taxing power. Does it make it better if the MTA says, we'll impose that income tax only on toll payers because they get an exclusive benefit? No. We have to look at whether the payment is for more than the exclusive benefit. And here, 58 cents of my toll dollar is paying not for the exclusive benefit of using the toll,
Isn't that true in
but for the
Bertone as well?
entire. I'm sorry?
Isn't that true in Bertone as well?
Well, in each of these cases, in Bertone, no. They were paying for a new electrical hookup, and the court expressly found that the exclusive benefit there was for the new electrical hookups, not for the existing electrical system. Contrast that with Barry, where it was for a sewer hookup, but they found that the payment was made not only for the new hookup, but to repair the existing system for the general benefit. Again, this distinction between exclusive benefit, that's a user fee, and some significant payment for shared benefit, that makes it an invalid tax. That's the distinction that we have here.
Yeah, at this point, you would agree that your prayer for injunctive relief is moot. The statute has been passed, which limits the money collected to the toll roads.
It does, Your Honor. We suspect that the diversion continues despite the statute, but that is true.
There's nothing before us that suggests that. But so what about your damages? I mean, the Attorney General takes the position that under the common law, you really can't collect damages here either. So what's this case all about at the moment?
It is absolutely about remedies. It's about, in the words of the United States Supreme Court in McKesson, meaningful, backward-looking relief. McKesson, as applied
But you voluntarily paid these fees.
Well, the payment, here's the issue under McKesson as adopted and applied by the federal court in Massachusetts in O'Connell Management versus Massport. The question, the voluntariness question by McKesson is stated this way. Has there been an opportunity to withhold payment? We're talking due process here, 14th Amendment due process. And the question is, do I have pre-deprivation procedural due process, or do I have post-deprivation process? Pre-deprivation process under McKesson means I have to have the right to withhold payment. I cannot go to that toll booth and put a little yellow sticky on my 2 quarters and say the other 50 cents.
At all. You don't have to go to the toll booth at all.
That's not the question, Your Honor. The question under McKesson is when I do the act that subjects me to the charge, when I do that act, can I withhold the payment? That is the McKesson standard. That is the O'Connell Management Standard. When I do the act, when I go to that toll booth, can I withhold the charge? If I cannot withhold the charge, I have no pre-deprivation remedy. And when I have no pre-deprivation due process requires that I have post-deprivation relief, and that is a refund action, meaningful, backward-looking relief. So we're entitled to remedies here. Now, if we can think again about the exclusivity test, because I think this really gets at it in both Emerson and Evansville. If we go to Evansville, the issue is the same. And I asked you to think back to your American history class, where we learned that under the Articles of Confederation, states could impose burdens on interstate commerce, and this created economic balkanization.
Are you getting to, is that where you're going?
Yes, interstate commerce.
What standing do you have to raise the argument?
Oh, heavens, we have standing because we're involved in interstate commerce. This is an interstate highway
As
system.
individuals are? You live in Massachusetts, you live east of the...
Beneficiaries of the trust, Your Honor, live throughout the region.
Well,
And-
you don't have a class action yet. You've got 3 or 5 plaintiffs, right?
That is correct,
They
Your
all
Honor.
live. They all live east of 128, don't they?
Members of the 2,000 or 3,000 members of the trust that
Let's just go
claim
to the
certification.
people who are currently plaintiffs. Where do they live?
We're not all over the United States, Your Honor, but that is irrelevant. Class certification, by the way, this court in American Trucking Association versus Secretary, the same ATA that's filed an amicus brief in support of us in this case. We're in a similar situation. The case got ahead of itself before class could be certified. And the court decided that the critical issues that needed to be decided could certainly be decided, and then on remand, class certification could be decided. This certainly involves interstate commerce. Transit from New York pays a heavier burden than transit from New Hampshire or Rhode Island. So in interstate commerce, the test here is there an undue burden on commerce? And Evansville has 2 tests, and the excessiveness and fair approximation tests go to exclusivity here. Think again about that box and draw it large or small. If I draw the box of services here small, just the tolled facilities, then those in the box are paying more than double what it costs to provide the services in the box. Excessive compared to the government's costs. If I draw the box large and include the entire multi-state highway system, Massachusetts highway system, as co-counsel would ask us to do, we've got another problem, don't we? Everybody's in the box, but only, more than half of them don't pay. So again, it's not exclusive.
But I mean, the dormant interstate commerce clause is designed to prevent a state from interfering with interstate commerce. If you put a toll perhaps on a border, then I can imagine an argument. But you're talking about tolls that are far from the New Hampshire or Rhode Island borders. I don't understand what the limits are of your dormant commerce argument. You're essentially saying the dormant commerce clause now is going to be able to influence every interstate commerce transaction, which incorporates virtually every transaction.
Your Honor, interstate commerce can be either invalid, a charge on interstate commerce can be invalid either if it discriminates, what you have outlined here, or if it unduly burdens commerce. Now think about Evansville.
Every tax burdens commerce. Every fee burdens commerce.
And every tax is subject to this analysis, especially when it's undisputed here. We're talking about the interstate highway system. Evansville and Northwest Airlines dealt with airports, which were within the confines of their states. Nevertheless, air travel is part of interstate commerce, just as travel on the interstate highway system is part of interstate commerce. Interstate commerce is something that is part of the very fiber of this case. The Boston Extension and the Central Artery are both interstates, Interstate 90, Interstate 93. We're involved with interstate commerce very much here, and we're burdening it. And again, a trucker coming in from New York is burdened compared to a trucker coming in from New Hampshire or up from Rhode Island. We have interstate commerce involved here. So when we do our testing of exclusivity...
Well, it just depends on what route the trucker takes. I mean, you don't have to go on the Mass Pike to come to Massachusetts. And you don't have to go, certainly, you can just go down 128 and come up Route 93. There's no toll.
You can. It's not relevant, however.
They're all interstates. It's just if you want to avoid paying because there's a specific requirement on a specific road, you can just avoid it.
Put another way, if you want to avoid the burden that MTA is putting on interstate commerce, you can avoid it.
Well, that's not the burden put on interstate commerce. It's a burden put on people who want to use the road, which is everybody who wants to use the road.
Is everybody in
Who wants
interstate
to road?
commerce.
Are your clients in interstate commerce? You're commuting to Boston. What's the interstate commerce piece here?
Again, the entire group on whose behalf we are here is involved in interstate commerce, as are amici, the American Trucking Association, their trucks coming in. We absolutely, this group that has joined the trust, 2,000 strong and growing, absolutely is involved in interstate commerce.
All right, thank you, counsel. Your time is up.
Although the legislature acted constitutionally before November of 2009, when it directed the Turnpike Authority to pay for the entire metropolitan highway system using tolls on part of the system, the court can and therefore should resolve this appeal without reaching the merits of the constitutional claims. These plaintiffs are not entitled to any relief. Their claim for injunctive relief is moot, as the Superior Court held. They're not appealing that. They didn't address it in their brief. And because they paid these tolls voluntarily.
Let me ask you this
Yes, Your
on
Honor.
that score. Assuming for argument that you're right about paying the tolls voluntarily, that, it seems to me, once they file suit in May of 2009 and they seek injunctive relief, which they don't get, but they seek it, isn't there an argument that between May and November of 2009 they've got some piece of damages, even under your theory?
No, Your Honor. There's no due process right here because there was no property or liberty interest that was either taken or threatened to be taken.
Well, but if this was on the merits an improper use of the taxing authority, that it isn't a fee or it isn't an excise tax or it just isn't authorized, there's a period of time there, at least as I thought about it, where even accepting your voluntariness argument, there would be a very colorable argument that it wasn't voluntary once they sought but were denied injunctive relief.
No, it continued to be voluntary, Your Honor. If they were upset about paying the toll during that period, they could have chosen to drive on other roads. Very simple. They could have taken any alternate route and not paid the toll. Their choice, after having been denied preliminary injunctive relief, to continue to drive on the toll roads remains a voluntary choice. There's no compulsion by the government, and that's the common law test. In the absence of compulsion or fraud, a voluntary payment to the government is not something that you can seek a refund on and not something you can leverage into a multi-hundred-million-dollar contingent fee lawsuit.
But if you're right, with regard to virtually every fee case, one could argue it's voluntary. They didn't need to build a house which was going to require a hookup. They didn't need to do a whole set of things which may invoke the fees. So is your view that all of those are voluntary?
No, and it's not this, I'm sorry, it's not this court's view. The court has distinguished in, for example, the American Trucking Association case that plaintiffs rely on, between cases where you have to pay a fee or be threatened potentially with a loss of your property. That was Emerson College.
Right, but his point is that he can't put in 42 cents for a dollar toll. He's got to pay the full dollar.
Or he doesn't have to pay the full dollar. He can drive a different road. This is not a case, unlike American Trucking, where the truckers would be threatened with the loss of their livelihood if they didn't pay the annual excise and get the sticker on the side of their truck. This choice at every instant in time remains voluntary. Somebody who wants to go to court and challenge these fees on a prospective basis, if they don't want to pay the fee in the meantime, they can drive on different roads. There's no due process interest implicated here. It would be a very strange rule of law that would say a person can go to the city of Boston, park on the street for an hour or two, pay a few dollars voluntarily into a parking meter, later on decide they don't like how the city's using that money, bring a constitutional claim, and assert a class action seeking hundreds of millions of dollars back from the city. That's not the right rule of law. It's never been the rule of law. At least as far back as 1865, this court held, and this was in Barrett versus City of Cambridge, 92 Mass, page 48, involving a betterment assessment, even where an assessment is later found to be unconstitutional, where the assessment's been paid voluntarily under no compulsion, there's no right to a refund. That rule applies here. And as the court recently reiterated in one of its Alliance to Protect Nantucket Sound decisions, of course, the court does not decide constitutional questions unless they must necessarily be reached. Now, if the court were to reach the merits on the state constitutional claim, there are three independent reasons, very unusual in this case, why these tolls were constitutional. First, they're permitted by Article 78, which of course applies to both fees and excises, so it doesn't matter for those purposes which this is. Article 78, as construed by this court in O'Brien, reflects the power of the legislature to charge any kind of exaction on using motor vehicles on public ways and use those monies broadly to fund transportation.
Mr. Griswold says that the case involving Massport and East Boston says Article 78 doesn't help you here.
The plaintiffs are wrong about that, and they're also wrong in similarly citing to this court's decision in Carlin. Massport was decided in 1966. The court treated the tolls on the Tobin Bridge collected by Massport as a tax, not as part of some holding, but as a general characterization of the activities of Massport. And plaintiffs seem to concede that the tolls here after November 2009 were a lawful tax because their use was constricted. That's a fine ground to uphold it. But Massport just wasn't dealing...
Lawful fee because their use was...
Lawful fee. I apologize. Massport wasn't addressing circumstances like this where somebody was saying, well, it's no longer a fee because the use to which the monies are being put is improper. So the issue alive before the court today simply wasn't addressed in Massport. It wasn't addressed in Carlin. Here, the exaction, of course, was expressly authorized by the legislature. Couldn't be clearer that there can be tolls paid. So Article 78 allows it. Second ground, again, the court doesn't need to get to the Emerson College analysis first if one of these other grounds is simpler, which it is in this case. Even if we didn't have Article 78, these tolls, just like the gasoline excise, could be considered to be an excise on the privilege of using certain public highways. In O'Brien, this court explained that the gasoline excise, which you pay every time you fill up your pump, is an excise on the privilege of using public roadways. Similarly, these tolls can be seen as an excise on the privilege of using particular roadways. The exaction is specifically authorized, and this analysis is easier than the Emerson College test in the circumstances of this case because the court doesn't need to even reach the particularized benefit issue or reach any comparison of revenues of costs, which are considerations under Emerson College to determine whether an exaction is a fee, but they are not requirements of the constitutional authorization for the legislature to authorize excises. Excises only must be reasonable.
But the excise tax on gasoline is charged for every gallon of gasoline, and it doesn't differentiate as to what road you're driving it on or what kind of a car you drive. It's assessed equally across the board. That's not true with the fees.
That's true, but an excise only needs to be reasonable, and it need not be something that is paid by everyone in the Commonwealth. The Constitution distinguishes in the same clause, the same article, between income taxes and property taxes, which do have to be proportional across all affected individuals or all affected estates, versus excise, where there's no such constitutional proportionality requirement. There's only a requirement of reasonableness. An excise is reasonable where it's being charged for a privilege which is voluntary, which this certainly is, and there's some fair approximation between the value of that privilege and the amount being charged. Again, it's not an accounting concept.
How do you decide the fair approximation? Suppose it was the toll payers on the toll roads. The proceeds were used to fund 90% of the costs of operating non-toll roads. Is that reasonable?
The Constitution doesn't ask us to look at how the monies are used. It's a fair approximation of the value of the privilege.
Well, how do you value the privilege is what I'm saying. I mean,
in a case like this, where the voluntary nature is so clear and it's so easy to avoid the exaction, the behavior of toll payers in willingly paying the toll is a fairly conclusive indication that they value driving on the roads more than they value paying the toll. If they didn't, they'd take some other route. So this actually is an easy case constitutionally.
And have you a case that supports that proposition, that you measure it by the, I mean, it seems tautological to me.
This court...
They do it voluntarily, therefore they do it, because they value it, and and that we don't have to look beyond anything else other than the fact that they actually use it.
Justice Lank, the best case may be Lilly Transportation, where this court held that an excise is reasonable constitutionally if it is a, quote, fair approximation of the value of the privilege, close quote. That case dealt with the motor vehicle excise. The delegation of power to levy these tolls was constitutionally adequate. The legislature only delegated the implementation of specified policy, raise enough money to pay the cost of the system.
So are you saying that, I mean, in a way that what Chapter 81 does is delegate the power to what? Tax, or the power to do what?
It delegates the power to fix and collect tolls. It is the Commonwealth's position that constitutionally it doesn't much matter if this exaction is considered a fee, a tax, or a hybrid of the two. Either way, it is lawful. If it's looked at as a tax, it's a lawful excise tax.
Because of the delegation?
Well, the delegation is constitutionally sufficient to meet the requirements of delegating. If it were considered an excise tax, the delegation is clearly lawful. If it were analyzed under the Emerson College test, there's no claim of an improper delegation. So we've only addressed delegation in the sense of explaining that even if this were analyzed as an excise tax, the delegation is constitutionally adequate. This court has held, for example, in the CNS wholesale grocers case, that the legislature may indeed delegate the power to fix and collect a tax. And so calling this a tax doesn't create a delegation problem. The court has made clear in cases like the Risk Management Foundation case that delegating the power to fix a sum and make sure you collect enough money to cover certain costs is constitutionally adequate. It sets sufficient standards. And the court recently held in the Clemmy case that where, like here, there's oversight both in the form of frequent reporting to the legislature and the availability to seek review under Chapter 231A, that's enough to make sure that the agency can't be abusing its discretion.
Well, would Emerson College have been decided differently if the argument had been made that it was an excise tax and not a fee?
No, the court addressed that issue in Emerson College. The court held that the exaction there was not an excise because it wasn't voluntary. Anybody who owned property had to pay that exaction. In contrast here, anybody who doesn't want to pay the toll can just drive another route. The main backdrop, of course, in Emerson College is that in that case, unlike here, if the exaction was not a fee, then it was a property tax, specifically because the activity couldn't be avoided through some voluntary behavior once somebody had bought the property. And so that constitutional backdrop, that requirement that property taxes be assessed proportionally against all estates in the same category or class of property, doesn't apply here, which is why the tax analysis is easier here than in Emerson College. As we've shown, however, the Emerson College test is satisfied as well. Most of the debate in the briefing was about the particularized benefit test. And the key point, as this court has made clear in Emerson College and the subsequent cases, the issue there is whether the service benefits payers in a manner not shared by others. There's no requirement that the service only benefit those who pay the tax. Bertone is on point, and plaintiffs mischaracterize it. In Bertone, the hookup charge was primarily being used to fund system-wide improvements, expanding the capacity of the system that, in fact, were used by all of the electric customers in the municipality. There was nonetheless a particularized benefit to those who had to pay the hookup charge because if the system had not been upgraded, the system couldn't have accepted new customers. So the physical improvements being paid for were used by everyone, and yet those who wanted new service got a particularized benefit, and thus the court upheld that fee. And so...
Finish your sentence. I just want to ask you this. Mr. Griswold, I think, thinks this, well, he said, this is not relevant, and I wondered your view whether it is relevant. The judge seemed to think it was, that these plaintiffs use the whole metropolitan highway system, not just the toll roads. So it's not just that they are paying $1 for 42 cents of value, but they actually get a value from the whole.
They get value in in three ways, I suppose. They, like anybody else, can use the central artery, but more importantly, they can access the central artery from the toll facilities, which non-toll payers can't. They, of course, also get the benefit that if the central artery, now having been rebuilt, is maintained and works, and it doesn't have traffic jams, then traffic doesn't back up onto the toll facilities like it used to. We all know that the tunnels and the Boston extension of the Turnpike used to be real bears to drive, all because the traffic wasn't moving to the central artery. So certainly there's a real benefit to the drivers of the toll facilities, even if they never get on the central artery, of having a central artery that works. One brief point on standing about Commerce Clause. This new amicus brief filed yesterday argued that an undue burden can be shown for the purpose of creating Commerce Clause standing, even if it's just a very small charge that's easily avoided. That's not correct, and the two cases cited in that footnote, Oregon Waste Systems and Sullivan, those were cases in which the fee was alleged to discriminate against interstate commerce. In Oregon Waste System, only out-of-state producers of waste had to pay a particular fee. In Sullivan, it was a toll case, but there was an exemption for local residents that was claimed to discriminate. Here there's no discrimination claim. And the case law is clear that paying a small fee, especially one that can readily be avoided by taking another route, simply does not create an undue burden on interstate commerce. It's not within the zone of interest covered by the Commerce Clause, and the court, if it gets past the remedy issue, can and should resolve the Commerce Clause claim for lack of standing, or as we've shown in our brief, the claim fails on the merits in any case.
Thank you.
Thank you, Your Honors.